Welcome to the DRE Way, where we discuss current events, frequently asked questions, and legal matters. When it comes to law, the only way is the DRE Way.
Darren, thank you for being here today. Kyle Rittenhouse just got his his case. He's not guilty. And we want to talk a little bit about that. The case was going on. It's obviously very heavily publicized. We wanted your opinion on kind of how things went down. Do you agree with the verdict?
Well, I think the verdict is legal, and I think it's just. And until something comes out to say that maybe there was jury misconduct, or perhaps the jury didn't understand the legal issues, it's going to stand.
So there is still a possibility that he could end up back in court over this.
Well, that's a concept called double jeopardy in this country, and he'll never wind up back in trouble with this again. But it can come under scrutiny. However, he's never going to be subject to any more criminal liability. Once you are gone as a criminal defendant through a trial, all the way through its entirety to a conviction or a not guilty verdict, and you do sustain a not guilty verdict, that's the end of the road for you. If, for example, you're a defendant and you're found guilty, you've got avenues of appeals that you can pursue, but for the prosecutor, that's the end of the road. A not guilty verdict means that you're done with the case and it can't be prosecuted again.
Okay. Now let's go back. You talked about potential jury misconduct. I know during the trial, MSNBC was actually banned by the judge because one of their freelance reporters was actually trying to follow the jury van back to the hotel where they were staying. Talk to us a little bit. Why would they ban them for that? What's the problem there potentially with the jury?
Well, the judge in any criminal trial can either order a jury to be sequestered in very rare circumstances, which means that they can't go home and they have no access to any electronic devices, and they literally go to court and go back home, go to sleep, and come back to court again to listen to testimony. Or they can be ordered by the judge to not discuss the case with anybody, not even their fellow juror members, and they can't watch the news or consider any reports that may influence their decision as a juror. So having a news reporter chasing the jury van back to wherever they were staying at the time goes against the orders of the judge, and it could subject the jurors to being motivated inappropriately by news reporters who want to take their statements, or, the curiosity always kills the cat. The jurors could say, oh, I wonder what this reporter wanted. It's from NBC. Let me turn on NBC tonight and hear what they have to say. The judge isn't going to want that because the jurors have to stay within the four corners of the courtroom and listen to only the testimony they've heard and the evidence that's been submitted and nothing more.
Okay, that certainly makes sense. I really appreciate that.
But a quick example, since we started with double jeopardy simply means you were in jeopardy once and you're not going to be in jeopardy twice, or double. But if he had sustained a conviction and there was a jury misconduct issue, a jury tampering issue, or examples of a juror that didn't follow the judge's order, those would be basis of appeal.
Okay. So in that situation, he would be able to appeal his case and try to go back and fight it because obviously that juror has been swayed.
Right. In this case, however, the prosecutor did not sustain a conviction. There was a not guilty verdict. So at best, you're going to have a bunch of legal scrutiny on the case for years to come.
I think we're going to probably definitely have that. Speaking of the prosecutor, he had a little bit of a rough time with this one. I know at one point the judge was basically essentially yelling at him for how he was conducting himself.
Right, and I think I recall exactly the moment that you're referring to because it caught a lot of attention in the national media. Those types of discussions are called sidebars, or they happen outside the presence of a jury. So the jury was excused at that very moment that I believe you're referring to when the judge says that you either may have or you did cross the line as it regards the defendant's right to remain silent. And that is under the Fifth Amendment, where a defendant can always remain silent, does not ever have to testify. If he decides not to testify in his own defense, no adverse inference can even be drawn from that because it's a constitutional right and it's to the core of American jurisprudence. And so what happened was that this defendant had never made a statement during the pretrial process. And the first time he ever talked about the case was when he was on the stand. And so the prosecutor then on cross-examination was going into the line of questioning, which called into question why he was staying silent, or even made reference to the fact that he had stayed silent, which does either blur the line or toe the line, or perhaps even cross the line to a defendant's right to remain silent.
Right, I think the judge even said that, he's like, this is basic law, it's been here forever, you should know this, and really got on his case. It's very interesting from my perspective, because I think in media and movies, we often think the prosecutors are the good guys. Every time I always think of Harvey Dent, the white knight of Gotham, that's, oh, he's out protecting against the bad guys. But in situations like this, it seems the DA is actually borderlining on trespassing across the line.
Well, I think he took some advantages, and I think he got caught, and each attorney is going to do that until they leveraged all of their opportunities to the extent that they have none left. Most prosecutors in this country, I would say, are well-intended. Most prosecutors want to do the right thing by society and follow law and order. Unfortunately, however, due to the resources or other hidden motivations, sometimes political motivations, prosecutors don't always do everything that's necessary to make sure that all of the facts are vetted out in the courtroom. And you'd be surprised that a case that's built on something looking like a duck and quacking like a duck and walking like a duck isn't always so.
Correct, that certainly makes sense. So there's a whole lot of drama that went on in this. I'm curious, in your experience, you've gone through a lot of trials, a lot of situations. Is it normal for it to be this way, or do you think it's part of it because there's media on it? Does that influence the trial and the court process at all because there was so much attention?
Well, I think you could see that some of the folks in the courtroom were playing to the cameras. I believe the judge was playing to the cameras. I believe if you were to walk into his courtroom 4 months ago, you wouldn't have seen exactly the same personality. And I believe if you go into his courtroom, should he still be presiding 4 years from now, he may not be the same. You could tell by how they articulated things and how they pontificated questions, or even just his general aggressive nature at times with being stern with his thoughts.
But that's the prosecutor swinging the AR-15 around in front of the jury.
Well, that is theatrics, and he's certainly allowed to do that.
Okay.
And he's allowed to do that if he gets permission beforehand. So prior to the trial actually starting and the jury being seated, they would have dealt with things called motions in limine. And those deal with issues of what evidence can come in and what evidence cannot come in. Evidence can come in if its probative value outweighs its prejudicial value. And that's the analysis. So at some point, that prosecutor said, hey, I really want to demonstrate how this gun was being wielded, and I want to use the actual gun. And that rifle being in front of a jury is very powerful, but unfortunately for that prosecutor, it wasn't powerful enough. The most powerful object between the prosecutor and that rifle turned out to be the rifle.
Correct. I really think that's definitely the case. So this whole thing started because Kyle was at a riot. He was at a place to protect places of business, to essentially oversee things as a first aid responder. I believe he was there as a medic capacity, but he had his weapon on him. The basis for the defense is obviously going to be self-defense, that these killings that happened were in self-defense. What do people need to consider when that comes into play? I mean, I was always taught to defend myself, but now it seems you can face legal actions and even a public trial on national TV for defending yourself.
Well, that is a loaded question, and we don't have time to go through it all today because there are 50 states in this beautiful country, and almost every state has some different version of self-defense law. But I would say another aspect of how this defendant was viewed is that he was trying to promote vigilante justice as well. And oftentimes that's not necessarily the most popular, but being that we practice mostly in California and federal courts, I'll just let you know that in California, we have a doctrine that compiles all of the laws on self-defense that simply say, hey, if you are in reasonable fear that you're going to sustain great bodily injury or imminent death, then you are able to, if necessary, use the force to stop that. And that force that's necessary to stop it must be proportional. So the way I like to describe this is if somebody throws a hamburger at you, you can't go back and shoot them. If somebody throws a knife at you, perhaps you could shoot them, and that's going to be a debate because the knife could hit your carotid artery. Who knows? Was it well intended? Was it well thrown? Were you legitimately in fear? In this state and most others, you also have a right to defend other people and not just yourself. So to the extent that you want to take up the defense for somebody else that's facing great bodily harm or imminent death, you also can do that, but it must be reasonable. And it's weighed against the reasonable person's standard. So
Okay.
if another person objectively would do the same thing that you would do, that normally means that you've conducted lawful behavior in your self-defense.
Okay. That really does help kind of clarify a couple of things. I think that even plays in here, like, that's what the jury has to look at. If they were in his shoes, what would they do?
Right. There was another issue that came up, which is that you can't go ahead and aggravate or provoke the situation.
Correct.
And then when that situation turns against you, start to claim self-defense. In some states, the law is that if you are the aggressor, you no longer have the right to claim self-defense, and you've essentially waived it.
Is that the case here in California, or is that?
It is.
Okay. I was curious about that. Let's see what else we got to go over here. So one of the ones we did want to talk about, this is also very much on the news, was drone footage. I believe it was actually from Fox. Fox owned it exclusively because they were the ones filming it at the time. There was a motion by the defense for mistrial with prejudice because they did not provide them a high-quality version of the footage that the DA had.
The leading law in the country is called Brady, and what Brady requires is that disclosures be made by both parties. And it says, hey, we're going to provide each side with everything we're going to use at the trial. But it also says that all information has to be provided to each side that may be inculpatory or exculpatory. Those are difficult terms to understand, so I'll try to make it easier for you to digest.
Sure.
Inculpatory evidence is that evidence that tends to find you guilty. Exculpatory evidence is that evidence that tends to find that you're not guilty. And so the debate in this particular situation was there was high value footage that showed exactly what was necessary for the defense to put forth to the jury to show that Mr. Rittenhouse was actually subject to attacks and therefore was justified in his use of force regarding his strategy in self-defense. But they were never, unfortunately, given that video surveillance. And so because it was high definition, because it tended to show aspects of the incident that would allow him to be not guilty, the defense attorneys were saying to the judge that, you know what, it looks like we've got exculpatory evidence that was never provided and it needs to be in front of this jury. Because it was never provided, I can't put it in front of this jury, so he's not going to have a fair and impartial jury.
That makes sense, yeah. I mean, if you can't show all the evidence, the person can't make the best decision.
That's right.
Missing stuff.
You've always heard that there's two sides to every story, but when we're talking about a criminal trial and a criminal case, there's about 100
4 or 5
sides.
people and all the witnesses.
Yeah, and you've got to have it all. And it's up to the jury or the fact finder to weigh all of that evidence. Your trial must be fair and impartial. Your jurors must be fair and impartial. That doesn't happen if all of the evidence is not in front of them.
Okay. Last one I did want to just quickly touch on is the jury was out for like 4 days. What does a defense attorney do during that time? Like, does the court just go on hold? What happens during that deliberation? What would you do in that position? Is there anything you need to worry about, think about?
There's a lot of nail biting that happens during that time, and there's a bunch of nerves. There's a general assumption that a quick jury verdict means that it's going to be in favor of the prosecution, and a jury that takes more time to deliberate is going to be in favor of the defense. 4 days is not necessarily a long time with a complicated case and severe consequences such as this one related to his felony charges. However, it tends to be parallel with the fact that they took a lot of time to consider the evidence. They wanted to make sure that they had the right decision. And even though it was out for 4 days, they came back with a not guilty verdict. But to answer your question, you sit there and you wait. And it's very nerve-wracking. For the defense attorneys, you have to be in the courtroom or near and able to respond quickly. For the prosecutors, their offices are usually very close to the courtroom, so they just go back to their office and then they get called by the court clerk when the verdict is in.
Okay. I think they even requested to watch the videos again while they were deliberating, like 2 days in, they're like, we need to watch this again, so that's.
Whenever there's a question from the jury, that is submitted to the bailiff submits that to the judge, and the judge takes a look at it to see what the appropriate response should be. Not all the times are jury requests or questions granted or answered, but in this case, some or most of them were, and it was able to help the jury make a informed decision.
That really makes sense. Darren, I want to thank you for your time today. This has been very insightful into this. I mean, this is national news. It's everywhere. There's a lot of good stories out there and a lot of twist things where people are viewing it in the news. So I'm really grateful to sit down with you, get kind of the criminal lawyer's perspective on the defense and everything and how this really plays out.
All right, anytime. Thank you.
Appreciate it. Thank you, sir.